So thanks for coming along today. My name is Michael, or MP for those who know me a little bit better. And I'm introducing in here Nicole, or Nick. And Nicole and I have worked together for about 20 years now. And one of the greatest strengths of Nicole is that she's a very intelligent person who can learn almost anything. And in particular, this particular area of our business has been one that's really caught her passion over the last couple of years and blends into her newish role as the head of analytics here at Pivotus. So she's working well within her giftings and her passion areas and has become extremely knowledgeable on both analytics, but also this extremely important part around data and privacy. So that's going to be enough from me. I might say something at the end, but I'll hand over to Nick to share her screen and talk us through the presentation for today. We do have time at the end for questions, but we also are very open to whacking your hand up or putting your video on or just speaking out and just asking for clarification if you need it as we go. So over to you, Nick.
Yeah, thank you. So feel free, if you do have questions throughout, to jump in. I might give my voice a bit of a break as well, which could be helpful. So feel free to do that. So thank you for joining today, and for those who were originally planned to join last Thursday, thank you for your flexibility on that. So today we just run through a bit of an agenda. I'm going to start just with a quick couple of slides on third-party cookies and what cookies are in general, just to make sure that will come up a few times today, that everybody knows what we're talking about there. I'm also, as mentioned, going to go through Australian privacy law updates, implications of those for advertising, both on the targeting and measurement side. I'm going to briefly just mention some AI considerations and give you some next steps. So I think the goal of today really, for one, is to give you an outline of what's coming so you can be part of discussions on what preparations you need to make, but also to give you some next steps and a list of resources of where you can go to deeper particular areas if there's areas that you feel are highly relevant to you. So first off, just on third-party cookies, or cookies in particular. Most of you probably know this, but it's going to be mentioned a few times. So cookies are small text or image files typically stored in a web browser to track user behaviour across the internet. There's two types, being the first-party cookie is the one that is owned by the site visiting. It manages things like site analytics, customization, quick logins. And then there's third-party cookies, which are the ones where most discussion is around, which are owned by an external party. So they have fueled a lot of measurement and audience building for digital advertising over the past decades. Example being a Facebook pixel on your website. There was a lot of talk in the industry over the last 2 or so years that Google was deprecating third-party cookies, which caused a lot of widespread panic in the industry about how they're going to make everything work now when these cookies disappear. Mid last year, they did a backflip on that and said, actually, we're not going to get rid of them. We're going to switch to a consent model, which gives the user consent over whether or not they're going to allow those cookies. Some people thought, well, what have we been doing the last few years? We've been getting ready for this cookieless future, and now it's not happening. Our view is that it actually is still happening, and that the changes to privacy laws which are coming into Australia, and similar to those which are in place in the UK and US and many other markets, are going to have a much bigger impact on the availability of cookies than any changes was going to make anyway. So this new consent-based approach that Google are going to take will result in data loss, and we'll talk a bit more about that as we go through. But the other fact of that is Chrome accounts for about 60% of the browser market. So Safari, Edge and Firefox, which some of the other leading browsers, have already removed third-party cookies anyway. So we are a large part of the way towards a cookieless future anyway. Okay, on to Australian privacy law updates. Before I go into it, I'm obviously not a lawyer. This is general advice and guidance for advertising. Please don't take it as legal advice and consult with a professional if you need to. Okay, that's the legal and that covered. Current privacy laws in Australia. So the last privacy legislation that was passed in Australia was the Privacy Act of 1988. Under that, we have the 13 Australian privacy principles from 2014, which guide how privacy is run and governed within Australia. Under these principles, all websites must have a privacy policy and a cookie collection statement to cover online data collection, talk about how it's used. We're going to talk a little bit more about that, the current laws in the future shortly. But in terms of what's coming, over the last, well, since 2017, there have been a number of different inquiries and reports published on our privacy legislation and whether or not it's fit for the digital age as it's known. So obviously, those laws were passed a long time ago before we all lived our lives in the digital world. The first round of changes were passed in November last year, being the Privacy and Other Legislation Amendment Bill. And that is the first part of what's expected to be wide-sweeping changes to our privacy laws. Broadly speaking, changes that are coming are expected to be around choice, consent, and control for humans. It's expected that once those laws are finalised, there'll be a 2-year window for businesses to become compliant. That seems like a long time, but as many of you will know, organisational change is a large activity to undertake and usually requires different steps and audits and stakeholders and sign-offs to make happen. So while 2 years sounds like a long time, in practicality, it's not really the scope of change that these laws are going to require. So first off, I'm just going to run through the changes that were passed in November last year. Broadly speaking, they weren't as wide-ranging as expected. The major changes in were additional enforcement powers for the OAIC, which is the Australian privacy governing body. They're in charge of enforcing privacy laws. What the industry is saying is this increase in enforcement power sort of sharpens the pencil and gives notice that they are going to be focusing on compliance at all levels. One of the biggest things that will be part of that and for companies to think about is whether your privacy processes actually reflect what's in your privacy policy. It's reasonably easy to have a policy which we do this, this and this and we follow the APP guidelines. It's not always as easy on a practical basis to make sure those steps are actually being followed. And that is what the OAIC is increasing focus on under this first round of changes. The second one is automated decision making, which where a computer is making automated decisions based on data that's being collected without human intervention. There are laws around that needing to be disclosed in your privacy policy, and particularly where the decisions of that ADM is expected to significantly affect the rights or interest of an individual. Some big areas of interest for that will be, finance companies where a computer decides whether or not somebody should be offered a loan or a finance product or an insurance policy. But also it can relate to, programmatic decisioning in advertising. I think there'd be some questions about how significantly that might affect the rights or interest of an individual if it determines which ads being shown to someone. But this change is going to force companies that are using a lot of automated decisioning to make sure that's disclosed in their privacy policies. And again, the way it's explained about being used in the privacy policy is actually reflected in what's happening within the company. Other major changes are serious invasions of privacy. There is going to be a new legal framework or a statutory tort which gives individuals right to sue for damages if they feel they've been victims of invasions of privacy. There are offences related to doxing in the Criminal Code Act now relating to the exposure of personal information online when it comes to those hacking events. Greater online child protection. So there is a Child's Online Privacy Code which has had the first draft introduced into Parliament as a result of this requirement. And there will be a new mechanism to prescribe a whitelist of countries for cross-border data transfer. So it's going to relate to where data is stored, where processing is happening. A lot of us are using cloud programs, so we need to make sure that the storage locations of those products are within areas that are on those whitelists. So generally speaking, there was a lot of talk in industry press, I'm sure you may have read some of it, that a lot of the big changes relating to advertising hadn't yet happened, and the industry it's been pushed down the road again. We're just in limbo until we know exactly what's being changed. The feedback from industry is that we do need to see this as the OAIC really increasing focus on companies across the board, how they're conducting their privacy and data activities. In November, which was shortly after this legislation was passed, the OAIC published some guidance on tracking pixels and privacy obligations for organisations. There is a link to this at the bottom of the page. I've copied an excerpt here, but the summary of this is that there is an increased focus on the notification and transparency requirements under the existing laws. So, we say that you need a privacy policy to say that you're collecting data and how that data is being used. What this notification and transparency rule is saying is that it needs to be an upfront notification to users that you are collecting data, as opposed to having it available in a privacy policy. So this guidance came in November, suggests that everyone should have an upfront notification on their website stating they are collecting data for advertising. I would suggest having a look through that article, and there's a bit more information on that towards the end. The second round now, and on to what's expected, and this is the sort of largest ranging area of where the changes are expected to the laws. We say mid-2025. All we really know is that it's obviously going to be after the election. No one's going to be putting up anything big in this area at the moment. It could be late this year, but it's expected, after the election. So the biggest part of the changes will be around definition of personal information and the consent requirements on the back of that. So the current definition of personal information under the Privacy Act is that it's information about an individual. It's expected this will change to information that relates to an individual, which will include things like cookies, device IDs, IP addresses. Some of the commentary is saying, as in this highlighted box here, it's expected that information will be regulated as personal if an entity can act upon specific individuals using it. So although I don't know the name or email address of someone, if I've got some cookie data on them or an IP address, I can, in theory, target them programmatically, which means then I have personal information on them and I need to make sure that's disclosed and I have consent to use it. So on consent, advertisers will be legally required to obtain a voluntary, informed, current, specific and unambiguous consent which can be easily withdrawn before collecting any personal information. This is typically done on a website by the use of a consent management platform or a CMP, which I'll talk about a little bit later. But obviously it will result in data loss. If we have to get explicit consent before placing a cookie, there's going to be a number of users who opt out. There's different numbers floating around. This blog article I've referenced here from Cookie Yes, which is a CMP provider, says between 35 and 80% of users opt out. I've read in other media somewhere it's around 70% of users tend to opt out of consent. I know me personally, I just tend to put yes and get it away from me so I can get on with what I've been doing online. But there is definitely going to be data loss as a result of this consent requirement. In addition to consent, users also need to be able to change their preferences at any time and request deletion, and that in itself means that there needs to be a system behind that initial consent that users can log back into and access. Another one which has been discussed in industry is that geolocation data may become categorised as sensitive information. Sensitive information is kind of a next level in terms of the definitions, where you have personal information and then sensitive information. Typically it relates to health or political, religious, things like that. Geolocation becomes sensitive information. It will have even more strict requirements on how it can be used, which is quite a basic level requirement. We think it's fairly fundamental that you should be able to target people based in Queensland or people based in Tasmania. So even that may become something that is highly regulated moving forward. The storage and sharing of data will also be under the spotlight, where it's stored, how it's shared, that sort of thing, whether you have permission to do that. Another expected change is the introduction of a fair and reasonable test, or the Aussie label of it, of the pub test. This will be a world first. There's no other market which has this fair and reasonable test, and what it does is goes beyond consent. Okay, you've got consent to use this data and this personal information. Even though you have consent, will the average person think the way you're using this data is fair and reasonable? This covers things like the scope and relevance of the data. Are you collecting data that is relevant to your business with the user, or is it nice to have information that might enrich your data set but doesn't actually relate to the relationship you have with the user? How are you using data, and is it only being used for the purposes stated at collection? How are you handling and storing it, and how long are you retaining it? How long prospect or customer expect you to keep their data as part of the relationship you have with them? So this will be an interesting one, because it prevents companies from using consent as a shield from bad practices. A quote there from Carly Kine, who's the Australian Privacy Commissioner, that this is going to be something that is scrutinised quite a lot. And as the laws come in and there are case studies and companies who are tried in different areas of the law, they will be publishing guidance and sort of case studies for organisations to refer to precedents. Other changes that are expected to come in, obviously with changes to personal information definitions and how data can be collected and used, the privacy policies will need to be reviewed. There will be expanded requirements for what needs to be covered in them. There will also be no exceptions. Under the current law, small businesses, which are those under 3 million in revenue, are exempt from the Australian privacy principles. Small businesses will have the same compliance requirements and face the same consequences as large ones for any failures. From an advertising point of view, there will be new advertising-related definitions, definitions of things like targeting, targeted advertising, and trading, which will further dictate how data can be used in these settings, and also what information needs to be displayed to users when shown targeted advertising. So some of the discussion that's been in place is that when a user is shown an ad, you would have seen probably the ad choices box on the Google served ads, display ads, but it will need to show things like why you're being shown the ad, what audience segment that means you've been shown the ad, how you got into that segment, and how you can remove yourself from that segment. Now, there's quite a lot of information there from a data pipelines point of view. There's a lot of work in the back of those systems that has to go in to be able to surface that information at the user point of view. So that's something the industry is working with on how is that going to be practical to display that information. The final one there is a privacy officer. So all organisations will need to have a privacy officer responsible for managing data and privacy related matters, including reporting of breaches. There's a few other things that, I've not mentioned here, but there will be a listed process for breaches, requirements for things like privacy impact assessments, and all of those will fall under the privacy officer. So that's the top line of the changes and the expected changes from a privacy law point of view. I'm now going to run through just some recent research on the consumer view of privacy. This was a report which came out in January this year. It was published by the US, in the US, but they did do some research in Australia and UK markets as well, which shows the comparisons on how Australians are feeling about privacy laws and what their main concerns are. So this one is the US figure, but it looks at what people's top of mind concerns are with how websites are now collect and use data. The largest concern by far is criminal activity. The smallest one at 2% is my data being used for personal advertising. So, I mean, the hacks and the data breaches and all that sort of thing, where people are concerned about. Personal advertising plays a very small part of what consumers are worried about when it comes to data and privacy. So, you know, I think it's key context of what the main concerns are. In terms of Australians specifically, and there's also data here in Brazil, Germany, Mexico, and the UK as having substantially similar privacy laws to the US, Australians being in draft mostly. Australians are in favour of sharing their data for the purpose of relevant advertising and free access to content. So broadly speaking, they are in favour of data being used to make their lives easier from an advertising and content point of view. In terms of familiarity with privacy laws, Australians come up very low compared to these other markets in our familiarity. And when you drill down, we have a reasonable understanding of basic privacy measures like account privacy setting and cookies. But when it comes down to advanced privacy rights like websites enabling you to see how your data is used, or the ability to access and delete data that's been collected, we're fairly low there, which sort of makes sense because most of that isn't currently legally required anyway. On consumer impact of privacy laws, 3/4 of Australians see privacy laws as a win for safer data and accountability, giving more control over that data and information and keeping data safe. So they do see it as positive. Although, and it makes sense because I feel the same way, just over half Australians feel overwhelmed by the constant consent requests. Most of you in your browsing endeavours get pop-ups all the time. That is going to increase as those consent requirements become needed in Australia, but it is a common phenomenon across these countries that consent banners are a bombardment and they interfere with our online activities. So it's just interesting to see, I think, how consumers view privacy law. You know, as a consumer yourselves, your own opinions on those pop-ups and things like that, and your own fears for how data is collected and used. I move on to the implications now for advertising. I'm going to start with targeting. I think there's two main areas of this. We've got targeting, which is how we can reach audiences, and then measurement, which is how we know what they've done after they've seen ads. So in terms of targeting itself, obviously we've talked about there's going to be restrictions on how data can be collected and used that will impact our ability to target campaigns using data. So this will impact the existence at all of third-party data sets, as well as the collection and use of first-party data. And one of the things that is quite reassuring from a practicality point of view is the IAB and ACMA, which is the Association of Direct Marketing and Advertising, are in a consulting group with the government bodies and the Privacy Commissioner on the development of these laws, working on the practicalities of what these new privacy requirements are suggesting will actually be implemented and how they will impact industry. So it's good to know that we do have people speaking on our behalf in the creation of these laws. Some of the things they're working on with government is defining what actually is identifiable information in specifically digital advertising context, specifying what a broad opt-out of targeting and advertising would mean, and whether, like I mentioned before, operational cohorts like location would be included in that. Just think how fundamentally we need to be able to target advertising to specific locations, particularly for, where there's particular PMAs that retailers have to advertise within, or, pricing limitations in different markets, different state laws relating to lotteries and things like that. There's all sorts of reasons that location does need to be available. So just working through that, and also the practicalities of displaying required information alongside targeted ads and the tech infrastructure changes required to do so. We do have a benefit as well, of course, in that the UK with the GDPR did a lot of heavy lifting in terms of the changing the privacy landscape, and being such a large market, and the US is in similar fashion, although their law is based. The platforms and tech providers have been working on solutions that those markets, and those will waterfall and already are waterfalling down to us, which is an advantage. So in terms of first data itself, obviously, the biggest amount of talk on when third-party cookies were going away and when we're starting to lose the third-party audience is that advertisers need to be creating and activating their first-party data to be able to reach audiences. For a number of small to medium advertisers, that comes with a scale issue. You might have this great first-party audience, but there's only 1,000 people in it, which is not necessarily going to give you enough scale to run a full campaign. So there's a number of different ways that industry and tech are coming to the party to help use first-party data. Platform tools is the most obvious one. Most platforms have got their own tools to enable us to use first-party data and activate that safely within platform. Google has customer match, Meta has customer audience lists, and LinkedIn's matched audiences. So, we can continue using those. I think the biggest consideration with those is going to be who's involved along that journey of getting that list into the platform. Ideally, if you have access to the platform yourselves, then you can upload those lists. There's no one else touching them. But if you've got to share it to an agency or to us, there need to be, agreements in place on how that's handled, where it's stored, making sure it's deleted off devices after it's been downloaded. So there's going to be a lot of steps to follow just to make sure that's done in a safe, privacy compliant way that meets your privacy policy requirements. GA4 is also being positioned as an audience tool in addition to purely site analytics. So GA4 audiences and predictive audiences can be used across Google platforms. I was also reading something the other week about Meta now being able to integrate GA4 in some areas. So Google is certainly trying to position itself and its GA4 as a way for first-party data to be used and activated across advertising platforms. And data clean rooms come more to the top end of the advertising budget scale, but data clean rooms are a technology which enable first-party activation and combining advertiser first-party data with addressable publisher audiences or platform audiences in a privacy-compliant way. So they can be quite expensive, but they are a large-scale solution for activation of first-party audiences. Just give me 1 sec. There are also publisher audiences and platform audiences and artificial intelligence which come into play here. So when we're talking about the ability to target, most publishers and or large publishers and platforms, DSPs, are creating their own identity solutions to help create addressable audiences for advertisers. So while Google was talking about cookie deprecation, third cookie deprecation, there was a lot of work done on what they called the privacy sandbox, which was going to be the solution to get around that. With that, there are a number of different APIs which solve for a number of different use cases of an audience targeting. So there's topics which help create audiences for interest-based ads. Protected audience API covers remarketing. Google is building those privacy sandbox APIs into the back of all of their platforms to help make up for the loss of party cookies and audiences. The Trade Desk also has their unified ID, which is a big identity graph on what they call the open internet outside the environment to allow people to target known users in that ecosystem. There are also AI-powered tools. So most of the platforms have their own AI engines, which are sitting in the back to help work towards advertising goals and objectives. Trade Desk has COA, Facebook has automated targeting and dynamic ads, Google has performance map and demand gen. And a lot of these, you might read bad reviews about them, about being, black box and closed to advertise. Advertisers don't really know what's going on. They don't know where their money's going. Google and Facebook are just taking it and where there's where they say it's going to work. I think a large part of this is a bit of shift in what advertisers have been used in the digital ecosystem of control and really granular insight into exactly what's happening. So it's a bit of a balance here of allowing these engines to produce results, but also being able to hold them accountable through third-party measurement, third-party tools, which are you to have a bit of a look under the hood and see exactly what is happening. On the targeting front, the last thing I wanted to say on the point was the re-emergence of contextual targeting as a relevant way of reaching audiences. So when, as over the last 5-10 years, data-based audiences have become, available, we can track directly and build audiences at the most granular level based on what they are or aren't doing on our website. The bit of a trend has moved away from contextual targeting, which is your old white list of running people on news sites or in house and garden verticals to reach people where they're possibly considering something as relevant to your product or service. There's a bit of research out there, and this is coming back into prominence at the moment, that contextual targeting can outperform data-based audiences. There's an article which I've linked in here about published in MI3 last year called The $700 Million Illusion, and it went through some research on how contextual targeting performed against first, second, and third-party data-based audiences. And the interesting thing was that in these experiments, the contextual ads did outperform off first-party data as well, and that obviously it's a lot cheaper. So I think, as well as looking at how we're going to keep targeting the pinpointed users that we know are going to convert based on our first-party audiences, it's also looking at how contextual can come into play to supplement loss in audience size from data-based audiences and increase relevance of the content around those ads. From a measurement point of view, and this is, I think, one of the scarier ones, because we've in digital have been so accustomed to being able to look at exactly how many clicks and site lands and conversions came as a result of this activity. This ability to measure that accurately is diminishing. So our traditional tracking is diminishing. There's also, in this survey was published in MI3, Apocalypse Not Now was their article in response to Google's backflip on cookie deprecation. Just looking at the fact that Australians do tend to clear their browsing histories 42% of the time, 23% roughly using ad blockers, and 21% are using private or incognito mode to protect their online privacy. So we do know that cookie-based audiences are diminishing. Our ability to measure directly is slightly reduced, so compared to what it was even a few years ago. So bringing consent requirements is going to make that even smaller. So that means our tag-based conversion results are going to be lower. Our cost per conversion, or apparent cost per conversion, is going to be a bit higher. That also impacts our ability to optimize on tag-based conversion events. So what can we do? From the measurement side of things, server-side tagging is a way to maximize the scope of measurement having place. So typically, measurement is done, let me get my mouse here, via client-side tags which sit in the browser. So under this structure, this is the browser, and these little icons are the platforms. The platforms are deciding what data they're going to take, thank you very much, from the tags that are on the website. Under a server-side structure, the server container sits in between the browser and the platforms and manages the firing of the tags, which means as the advertiser, the owner of that server container, you're controlling what data is sent to those different platforms. That gives the advertiser control over what is shared with the platforms, which increases privacy compliance. It is also less affected by browser loading areas, connectivity issues, and ad blockers. Server-side tracking is still subject to consent requirements, so it's not a way around consent rules. and it can be complicated, expensive to implement, but it does give the largest visibility across trackable users in market. So while utilising tracking and data from tracking, server tagging is the most future-proof way of protecting that. In terms of the things outside of that, industry is working heavily on solutions to the measurement problem. Obviously, each of the platforms as well have an interest in being able to continue to boast about their success that they're generating for you as a result of their campaigns. The IAB late last year launched AdMap, which aims to be an industry standard for tracking and conversion measurement that is privacy compliant, that is still being developed and will continue to be worked on. That will be something I would expect that the platforms themselves to adopt, as opposed to being something advertisers will be needing to work on. Once again, AI and machine learning is going to come into play here. So most of the platforms are already using those to measure and model unmeasurable conversions. And you'll see that if you're ever in platforms looking at the numbers, there'll be little tags saying we use modelling to fill in the gaps where we can. Obviously, that still requires some base level of solid data to model off. The benefits as well of AI and machine learning is it's enhanced data analysis. They can process vast amounts of data to pick out patterns and trends that are detectable. It can also look at predicting future outcomes based on historical data. So there are a lot of benefits in using and leveraging the AI and machine learning tools that the platforms have in place to continue to prove results. From a measurement point of view, for small to medium advertisers, often, you can't necessarily afford to be even doing site tracking. It can be quite expensive to implement, though there are more scalable solutions coming out, and we are working on some of those ourselves. It is also an opportunity to take a step back away from the really granular focus of digital advertising, where we're looking at clicks and conversions that have come as a result, and look more broadly at brand awareness and engagement metrics, at how business results are changing in alignment with campaign activities, and looking at test and learn and other ways to prove whether or not advertising and campaigns are getting results. So recently I was doing one of the IAB short courses on market mix modelling, just to fill in some of that foundational information. And one of the quotes there from Lisa, who's a research director at IAB, is that there is no silver bullet for marketing measurement. There's no one metric or tool to give a full picture of advertising effectiveness. And that's something I think that in digital advertising we've been very focused on. The result comes out of the platform as the gold standard of this is actually what's happening, but there is always things that are unmeasurable and longer term effects of campaigns which need to be taken into account. So I wanted to just briefly mention the gold standard of measurement here, and this is something that we're working with a lot of our clients on in looking at the 3 pillars of measurement. Not all of these are within reach of all advertisers or relevant to all industries, but when we talk about measurement, most of what we're talking about is digital attribution, where we've got all the points along the journey and we're just assigning credit along the way of those. It's very granular. The next part across that journey is experiments, controlled experiments and testing to look at incrementality, because what in terms of measuring advertising effectiveness we're really wanting to understand is where you've got 2 equal groups of treatment and control, an ad exposure or other marketing plan element is withheld from one of the groups, and you can have a look at what the difference in result was after that campaign. So really trying to understand if this campaign or this channel did not run in this market, would we still have got those results, and what are the results that were directly caused by this activity. So testing and controlled experiments that are done scientifically can discuss some of those questions. The final level in that is marketing mix modelling. So it's a statistical technique which users tries to isolate different variables of the marketing mix to look at what is actually driving change. It does rely on large volume of data and a large amount of historical data to get results, but it is a part of the ongoing way that campaign results can be measured and effectiveness understood. I want to briefly mention AI considerations and talk a little bit about how AI is filling in some of the gaps in both audience and measurement. The IAB speak about again brought out a state of data report just at the end of last month, and its focus was on AI and its use in media campaigns. There is a link at the bottom of this slide. I would really suggest if AI is something you're interested in looking at either internally as part of your planning or to understand more about how it can be used in marketing, that report is really useful. It also has a companion guide which gives specific suggestions for use planning, activation and the analytic stages of the campaign life cycle. So I'd really suggest that's a good one to look at if AI is something that's top of mind for you. And it's one of the big things that comes in step 2 in their top 5 points is ensuring data readiness. So quality, security and governance of data, and that's going to be key to what we're doing with this privacy and data compliance, is making sure that everything's clean, we have permission to be using and storing everything, and how the correct processes are followed. The other thing on that, the OAIC has published 2 guidance articles on the use of AI. So the first one is commercial available AI products, so your ChatGPT type of thing, on how to use that in the corporate environment, what content you should and shouldn't be putting in there, and not any of that needs to be mentioned in your privacy policy. There is also an article on developing and training Gen AI models. So if you are building AI products within your company, there's some guidance there again on how those need to be privacy considerations for AI in that environment. So in terms of next steps, I mean, there's sort of things that were covered here. The next steps I've really focused on are less from an advertising point of view, more corporate data governance point of view. It is going to take time for all companies to be ready for the changes, privacy laws that are coming in. The best thing that we can do, and I know certainly we're doing this at Pivotus as well, is looking at scenario planning and considering what changes will be needed if and when those changes come in as expected. I think the biggest thing, and the thing that will take part of the largest time, is a privacy and data audit, looking at that new definition of personal information and thinking about data minimization. What types of data do we hold? Do we need it all? Is there anything that we have held on to because we've always had it but we don't actually need it? We need, in that case, just safely delete it and get rid of it so you're ready. Review storage handling procedures, review current systems and access permissions. Privacy policy and data collection statements will also need to be reviewed. Things as well like ownership of your tech, data and marketing stack. This will be another big area that becomes part of this. If a platform is collecting data for you, who owns the seat? And a lot of our bigger clients own all their own seats in all the ad platforms. I think that's something that is going to become important moving forward. Who's owning those? Review current notice and consent in line with new expectations. So as part of that, from a website compliance point of view, if your website doesn't have a cookie notification banner, I would suggest that is something to look at. This is the step before an opt-in requirement, but it is making sure that you are compliant with the transparency requirements of the current laws. Just probably telling users of the website that you are placing cookies and using that to analyse site traffic and advertising, and then pointing to the privacy policy. This will make sure that you are, being upfront with users on what you're doing, that you are collecting. The next step is looking at researching consent management platforms. So a CMP is the one that sits on the website saying whether or not you accept cookies. Some of them are allow granularity of particular types of cookies you can accept and reject. Others have an accept all. These they can be expensive and a little bit detailed to implement, or they can be fairly simple. It depends on what your requirements are, what sort of data you're collecting, also what industry you're in. The CMPs will work in conjunction with consent mode. If you are advertising in the UK, you have to have consent mode enabled, and consent mode determines whether or not your tags are allowed to fire. It's a CMP that tells it for a particular user whether consent is in place and the tags are allowed to fire. So implementing these will result in a loss of data because there are people that will reject, but that's why looking at it early and starting testing where you can is a good option, so that you can see what works best, wording, what combination of buttons, what colours the buttons should be. All those sort of things can have an impact on acceptance rates. Different CMPs have different levels of testing they allow. They can have different settings in different markets that you can test as well. So while these are not legally required across most areas, it's a good idea to start looking at and testing what's going to work best for you. The final two slides are just resources. So this one, if you're looking for particular information or wanting to ongoingly keep up to date with what's going on here, ADMA, IAB, Trade Press and the OAIC have obviously got a lot of content that's relevant. ADMA has a privacy and compliance for market course, which is a paid course, but that's looks like quite a good one if you're really wanting to make a release for your business. The final slide here is just a list of all the links that I've used throughout the presentation grouped to topic. Just might make it a little bit easier if you're wanting to go back and dig into anything I've mentioned. We're up to questions there. Thank you for those of you who submitted questions ahead of time. Hopefully I've answered most of those. There's just two that I wanted to pull out and speak about briefly before we open up to any other questions. This one about learning from other markets. Sorry, let me have a drink. So as I mentioned earlier, obviously the UK and the US are ahead of Australia in privacy laws, and I think the big advantage in terms of learnings that has for us is industry and government are both looking at these other markets to understand what has worked, what hasn't. The platforms have developed tech solutions to ensure compliance with those. So Australia certainly is at an advantage here as a bit of a late updater of our privacy laws of what's worked in other markets. So I think that is the biggest advantage in the fact that industry is advising government on what has and hasn't worked. Okay? In terms of planning for smaller campaign bursts like Facebook lead gen, I think the planning itself will be mostly unchanged. The biggest part of it is where you're using things like Facebook lead forms, just considering how that data is handled once it's gone into Facebook and how that gets back to the end user, the people who are acting on those leads. So Facebook and all the platforms are really good at making sure you've got privacy policies linked in their data, in their lead forms, and you have data collection notice on there. But if you don't have a direct CRM integration with Facebook to pull those leads directly into your CRM, it's about considering how that name and phone number and email address is getting back to the person that needs to call and follow up on that lead. Sometimes it's automatically shared via an email or some kind of an automation, but just making sure, again, you have some kind of contract in place so that anyone who's handling and exposed to that list is handling it properly, deleting it off individual devices, and that your privacy policy is being followed along that journey when there's Facebook lead forms or forms in place. Okay, are there any other questions? There was quite a bit covered there. Hopefully it met some of the questions you had coming into here. Are there any questions that came up that I've just spoken through?